Hello students, I hope you are doing well. So let's start this lecture. I am Guneet Kaur and I'll be delivering a lecture on Sales of Goods Act 1930. So moving ahead, let's discuss what are the implied warranties in a contract of sale. So likewise, we have discussed the implied conditions. Now we'll be discussing what are the implied warranties in a contract of sale. Number one, implied warranty of quiet possession, section 14, subsection B. Students, like I've already told you that implied conditions are from seller point of view and implied warranties are from buyer's point of view. So first implied warranty of quiet possession means law says whenever sale has taken place, now buyer has the right to hold goods without any disturbances. He can enjoy the quiet possession of the goods. So this warranty is an implied assurance given to the buyer that he shall have and enjoy quiet possession of goods without any disturbance from the seller or third party. Whenever sale has taken place, buyer now has the ownership of that good, and now he can enjoy the ownership. He can enjoy the possession of the good without any harm and without any third party hindrance. So this is an implied warranty. Implied means something which are imposed by the law. Second implied warranty is as to free from liability or encumbrance. Free from liability or encumbrance, section 14, subsection C. It means whenever the goods shall be free from any charge or encumbrance in favor of any party not declared to the buyer before or at the time of making the contract. So I'll give you an example in this. Understand students, A has borrowed money from B and he has pledged his motorbike for that money from B. It means A has got some money against the motorbike which he has pledged with the B. Now A is supposed to pay back that money to get his bike, right? This is the pledge, meaning of the pledge. But now A fraudulently asks from B that I'll give you the money, but can you please give me my bike for 2-3 days? And B trust him and give him his bike. And later what A does, A resell the bike to any third party C. So now the buyer of the good is C, but there is some liability on the good which he has. So now it is the liability of the seller to discharge that liability so that the buyer C can enjoy the possession of the good. It is a duty of the seller to discharge that liability, or the buyer C can discharge that liability and enjoy the quiet possession of the goods, and later he can recover the price. Moving ahead, implied warranty as to quality of fitness by usage of trade. Implied warranty as to quality. Similarly, like we have discussed in implied condition, section 14, subsection C, implied warranty as to quality of fitness for a particular purpose may be annexed by usage of trade. Again, buyer should have also the right, that he should get good quality products for the usage of trade. Next implied warranty is implied warranty to disclose the dangerous nature of goods. It means whenever seller is selling something which is of hazardous nature, of dangerous product, it is the duty of the seller to disclose that thing to the buyer. For example, whenever somebody is selling crackers during Diwali time, although these are banned nowadays, but if somebody is doing so, it is duty of the seller to properly disclose this thing to the buyer that you are buying a hazardous nature product and this is a dangerous item. So there's an implied warranty. This is something imposed by the law to disclose the nature of goods to the buyer. So these are the implied warranties that we have discussed. Moving ahead, our next topic is Doctrine of Caveat Emptor. So again it's a very important topic, Doctrine of Caveat Emptor, and it means let the buyer beware. So caveat emptor means whenever buyer is purchasing anything, it is the duty of the buyer to take care of the things that he is purchasing, to check the things properly so that he should not go back to the seller and say what you have given me, because it is his duty. Let the buyer beware. So let's see what all we have to cover in this doctrine of caveat emptor. So the maxim of caveat emptor means let the buyer beware. This principle states that while buying the goods, the buyer must act with a third eye and ear. So it says whenever buyer is making a purchase, he should be very diligent and he should, use his third eye and ear, which means it is the duty of the buyer to thoroughly examine the goods which he intends to purchase. The one thing is thoroughly examine the goods before purchasing. Next is, if the goods turn out to be defective or do not serve his purpose, he cannot blame because it is the duty of the buyer. Third is, the seller is under no obligation to reveal the defects in the goods which he may be cognizant. The seller is not obliged to reveal the defects. And next is, there is no implied undertaking by the seller that he shall supply the goods which will suit buyer purpose. So under all these cases, the crux is that seller liability is less as compared to the buyer obligation. Doctrine of caveat emptor says that the buyer beware. Let the buyer take proper care. It is the duty of the buyer to examine the goods before purchasing. He cannot go back to the seller and ask that what you have given me and pay back me the price or refund the price. He cannot say that. So the doctrine of caveat emptor says that buyer has to properly take care of the goods, properly, examine the goods before purchasing. Moving ahead. So this is the last topic of this video, of this lecture, which is unpaid seller and his rights. So in Sales of Goods Act, we know that there is a sale transaction taking place between a seller and the buyer, and buyer is liable to pay the price. But there are certain situations and there are certain rights. What if the seller is not paid the price? Seller has not got the price. Seller has not got the money. So who is an unpaid seller and what are his rights against the buyer? So let's see who is an unpaid seller. So according to section 45, subsection 1 of the Sales of Goods Act, the seller is deemed to be an unpaid seller when the whole of the price has not been paid. Whole of the price has not been paid or tendered. Whenever the seller has not received the price of the goods which he has sold, the seller is termed as an unpaid seller. Second, when a bill of exchange or other negotiable instrument has been received as a conditional payment, but which is subsequently dishonored. For example, you got a bill of exchange for the goods that you have sold, but after some time that bill of exchange is dishonored, means you have not got the money, you have not got the price. So it says that the seller will be termed as an unpaid seller whenever he has not recovered the price or the bill of exchange that was rendered to him has been dishonored. So let's look at that example. A sells his motorbike to B for ₹60,000 and receives a check for the price. Subsequently, the check is dishonored due to insufficiency of funds. A is an unpaid seller. So in this case, A sells his motorbike for a certain price. He receives the check, and what happens is that subsequently the check is dishonored. So A will be termed as an unpaid seller. Moving ahead. Rights, remedies of unpaid seller. So this is the last topic that we'll be discussing on the Sales of Goods Act. What are the rights? What are the remedies of an unpaid seller? So whenever the seller has not got the price, he has not recovered the money for the goods which he has sold, he has certain rights against the goods, against the buyer. So against the goods, where the property in goods has passed, where the property in goods has not passed. So two things can happen. You have right against your good. Maybe you have already sold that good. The property, the right against the good are not with you. It is with the buyer. Or maybe the right of the good where the property in the good has not yet passed. So let's see. In the first case, where the property in good has passed, right of lien, right of stoppage of goods in transit, right of resale. So right of lien says section 47 to section 49. Right of lien says the right to recover the custody, the right to recover the possession of goods. If you have sell that good to the buyer, now you can go to the buyer and say that since you're not paying money to me, I want my good back. That generally happens. For example, if you have sell your car and you have already given the ownership of your car to B, and he has refused to pay the price, you can say to him that, I have the right of lien, give back my car, and I can recover the price no matter not paying me. So that's right of lien, means right over the custody of the good. Next is right of stoppage of goods in transit. So sometimes there are situations that the ownership has not yet transferred. The delivery of the goods is in transit. For example, transporter is carrying the good. Now you have the right of stoppage of goods in transit. You can call to the carrier and say that since that buyer has refused to pay me the money, you should not deliver that good to the buyer. Return back the good to the me. So you have the right to stoppage of goods in transit. Next is right of resale, section 54. You have the right to resell the goods. Since one buyer has refused to pay, now you can sell that good again, resell that good again to any third party. Where the property in goods has not passed, right of withholding the delivery of goods, like right of stoppage of goods in transit, you can also have the right of withholding the delivery of goods. The goods are still with you. You can directly refuse to pay. You can directly refuse to say that, I'll not send my goods because you're not paying me the price. You can withhold the delivery. You can hold the delivery of the goods. Second, the secondary rights, right against the buyer. The seller also has certain rights to file a suit for price, to file a suit for damages, suit for repudiation of contract, suit for interest. So in all these situations, in all these cases, the seller has the right to legally, to have legal consequences. He can file a court case against the buyer to recover the price, to recover the damages, to recover any interest or any other expenses that the seller has borne. And since now the buyer has refused to pay back the amount, he can file a case and recover all these money legally. So this is a very important topic. What are the remedies of unpaid seller? I hope all these things are clear to you. And let me know if you have any queries. Thank you for watching. Thank you for taking out the time. Thank you, everyone.